officially, as of this week, the Karen Reed trial is going to start. And they're doing jury selection this week. So I wanted to do a little bit of rewind and go back and see this last emergency hearing that recently took place and find out what's actually going on in court. And maybe we can get a little bit of an update. If you're not familiar with the Karen Reed trial, do not worry. I gave you guys a very thorough update of what's going on, what you can look for in this trial coming up. We had some news and updates about some of the people who are going on to Karen Reed's side and joining her defense team as well. So if y'all haven't caught that, make sure you check the links in the description. And you can also check out our Karen Reed trial playlist, and that'll list out every content we've made on Karen Reed so far. All right, let's go ahead and get into it.
Judge, this is 22-117 and 23-313, Commonwealth versus Karen Reed, and separately the Commonwealth versus Aiden Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please.
Sure.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you. Okay, Mr. Clerk, you
Judge,
may call the
thank
case
you.
and identify the parties.
22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the
We'll
Commonwealth.
get you guys right, don't worry.
Relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm the special prosecutor on the Aiden Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aiden Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Bradel.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so.
No,
okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615.
What was the order, Judge?
615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records,
Break it
Attorney
down,
Brennan
Judge.
specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced.
Interesting.
However,
they're trying to get some
subsequently,
communication.
The special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Rado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney.
I love it, Kelbell.
I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other?
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Oh, how
Okay,
nice.
well, we all agreed, counsel, that those, in fact, would be privileged communications without question.
Of course.
So let's turn to, if you would, the
So he still
second
wants it,
issue,
huh?
which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any
Indubitably.
attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy of Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043, in that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It's suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel, and so I think it's
Judge is speaking
appropriate at this
Chinese
time,
right now, but we'll
Attorney
figure it out.
Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys from Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Carney and Ms. Reed.
I'll stop you right
Nothing
there,
about
Attorney Bradel, because you
lawyers or
raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that that is what might be at issue, but I will probe further of 88 Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are absolutely, we are privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Carney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that, and we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order.
Y'all like this judge better than the other one?
And Reed.
Y'all don't like Bev?
Third parties that may or may not have spoken to Reed, and these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate. In particular,
it's disrespectful, to be honest.
These two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank you. Attorney Bradel, I'm going to ask you to pause for a moment, and I'm going to hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to to Mr. Kearney. I think that they.
So
act
what's their issue
together
here?
in that respect, Your Honor?
They just want to get access to this information.
Attorney Cosgrove. Notwithstanding
Why?
that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry.
He said it's
So
none of your business.
I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the
Yeah, I can't wait to see
will
Bev.
only
Y'all can't stand
include
that lady.
Communications between Kearney and Reed.
Well, I will, of course, comply with Your Honor's order.
Thank you.
But-
Folks, I think we've covered that point, and I don't think
He
I need
said
to go any
next.
further on this. The order is clear on its face, and I expect the parties to
Okay,
comply with it.
Judge.
I'd like to turn now to the issue of the motion for protective order from Mr. Brado. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not. I'll preview where I end up, Attorney Brado.
Oh,
I'm
y'all
not
are ready
quite
for this
clear
Karen Reed trial.
on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. I am not. This is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court.
So
in
what's
the
Aiden's
Kearney
case about?
And that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So
Alleged witness
I'm not
intimidation.
prepared to discuss the entirety of
okay.
investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties
Interesting.
not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
Yeah.
They are, Your Honor. Judge Cannoni specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless,
So no
as
interviews.
shown in my exhibits, Judge, that these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Cannoni's suspenders?
I think so, Judge, because we need one, and we need one as to this.
He said they're out here tripping.
These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order you know, it's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either, based on my exhibits A, B, C, and so we're asking for another step to just really put a fine point on it, that these three people must stay away, and a general order as well as part two is my part two. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Bradel. Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So
you got the special prosecutor leaking
statements in an effort to make us look bad.
Leaking stuff?
It was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. You know, again, detailed, you know, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, 88 Cosgrove, Special 88 Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for?
Get Page in there.
17 motion.
Shout out to Judge Whitaker.
Probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed a Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood.
Yeah, because that's what it sounded like.
Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
All right, so there it is. Interesting stuff. This prosecutor looks like he's not gonna take no for an answer pretty easily. He was up there challenging the judge, say, hey, I don't agree with this decision. I don't think it's the right decision. Special prosecutor next to him said, I agree. I don't see what the issue is here. The judge said, y'all need to get it figured out, and you got Monday. So let me know what y'all think about this in the comments and in the chat. It's going to be some interesting things moving forward. I know y'all are saying in the chat that you like this judge better. You're stuck with Bev. I think it'll be interesting to see. Either way, trial is starting soon, so y'all make sure you stay locked in, subscribe, hit the notification bell so you don't miss any time we cover this Karen Reed trial and what's going on here.